Okay, Dolphin Kidnapping Crew, or Dolphin Kidnappers, or 돌고래 유괴단 in Korean, officially appealed the ruling that ordered them to pay 1 billion Korean won to ADOR for uploading NewJeans ETA director's cut without written approval. Now, at the same time, the company asked the court to pause enforcement, trying to delay payment while the appeal moves forward. So we're going to talk about that. And it turns out right before I, decided to film or record this video, Shin Woo-seok himself made statements through his Instagram and through the company Instagram. Okay, so I'm going to cover that at the end as well. But now, this appeal isn't just about damages, because I don't know if you remember, during the trial at the end of last year, Min Hee-jin appeared as a witness to defend Shin Woo-seok, right? And in that process, it became clear that a shareholder agreement between Shin Woo-seok and Kakao Entertainment was shared and leaked somehow, okay? And that contract included some extreme profit targets and personal liability and exit restrictions. And we actually talked about this on our channel last year in May through some articles that somehow had access to that contracts. So we're gonna talk about that also. And in this video, so we're gonna break down what the appeal, first of all, really changes, and why that exposed shareholder contract matters far more than the 1 billion Korean won, this damages lawsuit that Shin Woo-seok lost, and how this loss ties directly into the much bigger case still waiting for a verdict when it comes to Min Hee-jin and HYBE. Okay, so let's start here. Today's article is an exclusive piece titled Dolphin Kidnapping Crew Refuses 1 billion Korean won damages ruling. NewJeans music video case heads into round 2. Published on January 21st, 2026. The advertising production company Dolphin Kidnapping Crew, which produced music videos for a girl group, NewJeans, has refused to accept the court's ruling ordering it to pay 1 billion Korean won in the damages to NewJeans agency ADOR. It has been confirmed that on January 20th, director Shin Woo-seok and Dolphin Kidnapping Crew filed an appeal against the first instance ruling in the damages lawsuit brought by ADOR. On the same day, Dolphin Kidnapping Crew also filed a request to suspend compulsory enforcement. Provisional enforcement allows the winning party to enforce a judgment even before it becomes final. The purpose is both to allow the prevailing party to realize its rights more quickly and to prevent the losing party from filing an appeal solely to delay enforcement. In cases involving monetary payments, courts typically attach a provisional enforcement order to the judgment. As a result, once the ruling is served, the plaintiff may immediately initiate enforcement procedures for the awarded damages. To block such enforcement, the losing party may file a request for suspension. Courts often grant such request on the condition that the applicant provides security, such as depositing cash or submitting a guarantee insurance certificate. Previously, on January 13th, 2026, the Seoul Central District Court Civil Division 62nd, presided over by Judge Lee Hyun-seok, ruled that Dolphin Kidnapping Crew shall pay ADOR 1 billion Korean won plus delayed interest, adding that the judgment may be provisionally enforced. The court dismissed ADOR's damages claims against Shin Woo-seok personally. Okay. The dispute began in August 2025 when Dolphin Kidnapping Crew uploaded the director's cut of NewJeans' ETA music video to its YouTube channel. After ADOR demanded the video's removal, Shin Woo-seok deleted NewJeans' related videos that had been posted on another unofficial fan channel known as the Pan Hee-soo channel, escalating the conflict. ADOR responded by stating that it had only requested the suspension of the ETA director's cut and had never demanded the deletion or upload suspension of all NewJeans related content, including the Panhisu channel. ADOR accused Shin Woo-seok of spreading false information. In fact, we're going to go back to the the back and forth that happened between Shin Woo-seok's Instagram and ADOR's Twitter account, okay, which occurred in September of 2024 at the end of this video. Now, back to the article. The article also says, Shin then filed a criminal complaint claiming his reputation had been damaged by ADOR's public statement. ADOR, citing ownership of the video, filed a civil lawsuit seeking damages. During the trial, former ADOR CEO Min Hee-jin appeared as a witness and sided with Dolphin Kidnapping Crew, testifying that verbal prior consent had been given to upload the director's cut. But the court ultimately ruled in ADOR's favor. Meanwhile, in November 2024, NewJeans declared the termination of their exclusive contracts, citing ADOR's alleged breach of duties. After legal proceedings, the court ruled in October of last year in favor of ADOR in its lawsuit seeking confirmation of the validity of the exclusive contracts. Among the 5 members, Hae-in and Honey returned to ADOR, while Min-ji continues discussions regarding her return. Danielle was notified of her removal from ADOR. Okay, so that was the exclusive article. In fact, we heard some of it yesterday from the Korean media. Here's one more article that I brought. I'm not going to read the whole thing. Just want to add that according to the decision, the judge, so the judge ruled that Dolphin Kidnapping Crew must pay ADOR 1 billion Korean won in damages plus delayed interest at an annual rate of 12%. Okay, 12%. That's pretty high. Meaning that time is ticking. But the court rejected ADOR's separate 100 million Korean won damages claim related to defamation against Shin Woo-seok personally. Okay, so that was one detail that I wanted to point out by including this article. Anything else? It has been reported that Dolphin Kidnapping Crew also filed a request to suspend compulsory enforcement alongside its appeal. Since the judgment allows provisional enforcement even before it becomes final, the move is seen as a precautionary measure. Provisional enforcement allows the winning party to enforce a judgment before it is finalized and is commonly attached to rulings ordering monetary payments. The losing party may request a suspension of enforcement to block such action. Okay, so the original ruling found that Dolphin Kidnapping Crew breached its service contract by uploading the video without prior written consent, right? Rejecting arguments based on verbal approval or industry practice. And the court dismissed claims against CEO Shin Woo-seok personally and rejected ADOR's defamation claim. But it allowed provisional enforcement of the 1 billion Korean won damages award. Now, the appeal that we just learned about moves the dispute into a second round of litigation, prolonging a conflict that began in August 2025 and has since expanded into parallel civil and criminal proceedings tied to NewJeans' IP and contractual authority. And the appeal does not change the core problem for Dolphin Kidnapping Crew, though, because the first ruling already answered the central legal question clearly. And what is it? Written consent was required, and it did not exist. So nothing in the appeal filings, at least as reported so far, suggests new evidence that could overturn that finding. And filing an appeal and requesting a suspension of enforcement looks more like a delay strategy at this point. And this is common in high-value civil cases, especially when provisional enforcement threatens immediate cash outflow. But delay does not equal leverage, though. It simply buys time. And what stands out is how little room remains for reinterpretation, because the court did not hinge liability on intention or reputation or creative contribution. It treated the upload as a straightforward contract breach. And that framing is kind of difficult to undo on appeal unless the contract itself is somehow reinterpreted, which seems unlikely given how explicit the written consent clause already is. So in practical terms, from my perspective, this means the second round is less about whether Dolphin Kidnapping Crew was wrong and more about whether it can reduce damages or negotiate settlement pressure or stretch the timeline. I don't know. Let's wait till the end of the video to hear directly from Shin Woo-seok himself what he wrote on his Instagram. But now, it turns out the January 13th ruling against Dolphin Kidnapping Crew was a major shock, especially to observers who attended the hearings in person. So, journalist Lee Jin-ho on his YouTube channel has explained that based on courtroom atmosphere alone that day, he genuinely thought Shin Woo-seok might survive the case. Why? Because Min Hee-jin herself appeared as a witness and took full responsibility, repeatedly stating that she personally gave verbal approval and that Apple was also handled verbally, and that Shin Woo-seok simply followed her instructions as ADOR CEO. And in doing so, she arguably exposed herself to further legal risk, including breach of fiduciary duty. But she did all of that to shield and protect Shin Woo-seok, calling him a star or whatever. Now, from the defense perspective, this looked like a clean escape route. So, Shin Woo-seok relied on the CEO's authority, i.e., that is Min Hee-jin. So liability should stop there. And Lee Jin-ho even recalls that Shin Woo-seok's lawyer appeared visibly relieved in court, as if Min Hee-jin's testimony had handed them a gift. But the court, what did they say? They ruled the opposite way. Now, why did then Dolphin Kidnapping Crew lose? So let's break down the court's logic into several decisive points. So, first of all, verbal agreements were acknowledged, but they did not override the written contract. And when verbal and written terms conflict, the signed written contract prevailed. Okay, and Apple headquarters, they never approved the upload, regardless of what individual employees may have said. And the service contract clearly states that all IP belongs to ADOR, not the production company. And most critically, the contract explicitly required separate written consent for public release of content. And that clause existed, and it was not followed. And because of this, the court concluded that the upload constituted a clear contractual breach, regardless of what intent or custom, industry practice, or whatever. And even if Min Hee-jin was a CEO, she was still bound by the contract. And acting unilaterally without written approval could itself constitute a breach of her fiduciary duty. And in fact, this reasoning may later hurt her position in the pending put option lawsuit because courts assess patterns of conduct across cases, and the decision for which will come out next month in February 2026. Now, let's also talk about ADOR's strategy. So ADOR originally had grounds to pursue 4 billion Korean won in contractual penalties because the contract set damages at twice the production fee, and the ETA video reportedly cost 2 billion Korean won. Like 2 billion for a music video? But instead, ADOR sued for 1 billion Korean won only, plus a separate 100 million Korean won defamation claim against Shin Woo-seok personally. Now, Lee Jin-ho, the journalist, explains why this matters, because courts cannot arbitrarily reduce contractual penalty amounts. So if plaintiffs demand an unrealistically large sum, judges may simply reject it outright. So by targeting a realistically collectible amount, ADOR maximized its chance of full recognition. And that strategy worked because the court awarded the full 1 billion Korean won against the company, while dismissing the personal defamation claim against Shin Woo-seok, which is why observers say that, wow, Kim and Jang is really, doing their calculations precisely. Now, let's also talk about the contracts, okay? Because the real danger lies in Shin Woo-seok's shareholder agreement with Kakao Entertainment, which contains some extreme performance conditions. Okay, so for that, we had to go back to these exclusive articles by a media agency called Top Daily that were published in February of 2025. Even though the headlines do not say exclusives, it was pretty something. And yes, we have talked about these two articles on my channel in a video with this thumbnail. Why did NewJeans MV director publicly attack ADOR? Okay, so from the moment the contract was signed between Shin Woo-seok and Kakao Entertainment, Mr. Shin was personally responsible for making sure the company hit a very specific profit number. Okay, and Dolphin Kidnapping Crew had to earn a total of how much? Total of 18 billion Korean won in operating profit by the end of the mandatory work period. 100, 1000만, 10만, 100만, 1000만, 10억, 100. Yeah, 18 billion in operating profit. And these are, the snippets of the actual agreement, shareholder agreement, the contract that were included in these articles, which was why it was so shocking when these first came out. Okay, so again, Dolphin kidnappers had to earn a total of 18 billion Korean won in operating profit by the end of the mandatory work period. So it's not revenue. We're not talking about projected income or something. We're talking about actual operating profit calculated month by month under Korean accounting standards. Okay, and if the company failed to hit that number by the deadline, Shin did not get to simply walk away or renegotiate freely. Instead, he was given two options, and both are not that great. First option is that he stays. He must keep working as CEO for another full year. And if the company still doesn't reach the target after that year, the contract allows the work period to keep getting extended again and again. And there's no clear endpoint written into the contract, which is why the article described the contract as a modern day slave contract. Okay, Min Hee-jin used that terminology, slave contract, during her press conference. But it turns out the real estate contract existed, yes, but not between her and HYBE, but between Shin Woo-seok and Kakao Entertainment. Second option, he exits. Shin Woo-seok exits, but only by triggering the penalty path. That path leads directly to repayment obligations and interest, which are spelled out elsewhere in the agreement, which is pretty huge. And the key thing to understand is that there's no clean failure state. Missing the target does not mean the deal didn't work. It just means either indefinite forced continuation of work or financial punishment. So in practical terms, the clause turned the profit target into a trap. And as long as the company did not hit 18 billion Korean won in operating profits, Shin Woo-seok was not truly free. and his time, his exit, and his financial exposure were all locked behind a number that was extremely difficult to reach without a massive, ongoing hit project. Speaking of which, that is why this clause mattered so much later. Okay, so here's a summary. Because Dolphin Kidnapping Crew's financial peak directly coincided with NewJeans. So in 2021, and we have talked about this on our previous video, right? On this case with this thumbnail. So if you look at the statistics, the data, in 2021, they recorded about the Dolphin Kidnapping Crew, the company recorded about 700 million Korean won in operating profit. Now, in 2022, with NewJeans era, they recorded over 3 billion Korean won in operating profits. Now, a year later, 2023, profits collapsed back to 434.3 million Korean won. And in 2024, NewJeans activity, when it halted, operating loss was recorded. So it's minus 245.74 million Korean won. So for them, NewJeans was not just a client. ADOR was not just a client. It was the core revenue engine that made Shin Woo-seok's Kakao contract survivable. I mean, 2 billion Korean won for a single music video. And once that pipeline disappeared, the entire structure became unstable. Now, some more details from these top daily articles. So yes, Kakao Entertainment agreed to pay 30 billion Korean won for Shin Woo-seok for his company on paper, but structurally, Kakao barely took on real risk because 16 billion of that money was immediately pushed back into Kakao Entertainment shares. Okay, so Shin Woo-seok has tons of Kakao Entertainment shares, non-public, meaning Kakao effectively recycled its own cash. So what looked like this aggressive and expensive bet on a creative studio was actually designed so Kakao could recover its money and more, regardless of how the studio performed. And second, this was not a one-off deal made for Dolphin Kidnapping Crew. The articles show that Kakao used the same structure repeatedly across multiple subsidiaries. So other studio heads, representatives, were also required to reinvest large chunks of their sale proceeds back into Kakao stock. And this tells you the deal was part of a system, not an exception. So Kakao was building a group of founders whose personal wealth was tied to Kakao's valuation and IPO success. Third, exit was practically impossible. Shin Woo-seok could not freely sell his Kakao shares and could not resign freely and could not fully realize his gains unless Kakao Entertainment went public at a high valuation. Until then, his money was locked. And this turns the usual, founder narrative on its head because he was no longer an independent creator who sold his company. He became a bound participant in Kakao's IPO strategy. And to borrow Min Hee-jin's terminology, he was essentially a slave under Kakao. Now, fourth, the contract did not just control profits. It reached into day-to-day operations. So Kakao had the right to cap, limit budget, and block salary increases and freeze executive pay. And that means even if the studio wanted to restructure and cut losses or adapt creatively, it was financially constrained from above. And growth during NewJeans era raised cost, right? But when revenue dropped later, the contract gave no flexibility to absorb that shock. Also, the downside risk was extremely asymmetrical. So if things went well, Kakao benefited through profit targets and IPO upside. If things went badly, the personal downside fell on Shin Woo-seok. So missing targets could trigger massive repayment obligations with how much? 12% interest. And the articles openly question whether this resembles a normal M&A deal or something closer to a modern day slavery contract. You know what I'm saying? And as we have also briefly talked about before, Kakao Entertainment IPO is not really happening anytime soon. It is unlikely at this point due to various issues. Now, at this point, there's a question we have to ask. Top Daily didn't just summarize the deal. They published specific internal terms of the shareholder agreement, like budget caps and reinvestment obligations and profit targets and penalty clauses. And these are not things that normally leak unless the document itself or close paraphrases of it circulate among multiple parties. In fact, like I said, the media agency even included the snapshots of the actual copy. So how did that happen? The most plausible route is already sitting in the court record. So for that, we need to go back to this November 2025, last year, article on the court case, the hearing between ADOR and Dolphin Kidnappers, for which Min Hee-jin appeared to as a witness to protect Shin Woo-seok. And let me read you a particular segment from this article. ADOR also stated that the plaintiff paid Dolphin Kidnapping Crew 3.3 billion Korean won in total for 4 music video projects in 2023. And that's when Min Hee-jin was a CEO, right? Again, 3.3 billion Korean won in total for 4 music video projects in 2023. And asked, are you aware that 3.3 billion Korean won accounts for 25% of Dolphin Kidnapping Crew's total 2023 revenue of 13.2 billion won? So they asked, ADOR's lawyers asked CEO. Min Hee-jin, no. They asked Min Hee-jin, okay, who was at the time a CEO of ADOR. And Min Hee-jin replied, I suppose so. ADOR then pointed to an article about the side agreement between Dolphin Kidnapping Crew and Kakao Entertainment, which I think is this, because these were the only articles that talked about it specifically. And they asked, where is it? Dolphin Kidnapping Crew recorded operating profit of only 700 million Korean won. Yet, under a stock purchase agreement with Kakao, it is required to achieve cumulative operating profits of 18 billion by 2026. Were you aware of this? Min Hee-jin answered, no, I was not. ADOR followed up by asking, did the defendant ask you to review Kakao's stock purchase agreement? And by defendant, we're talking about Shin Woo-seok. Min Hee-jin responded, no, or maybe I passed it along. I don't remember clearly. At this point, ADOR presented Kakao Talk messages exchanged between Min Hee-jin and it says Vice President Lee, L, but I'm pretty sure that is a former ADOR VP, Lee Sang-woo, okay? A former accountant. ADOR asked, these messages show you discussing the stock purchase agreements and how the shares could be bought or sold. You received this contract for Shin Woo-seok, correct? Min Hee-jin replied, yes. ADOR then asked, knowing that Dolphin Kidnapping Crew needed to achieve 18 billion Korean won in operating profits under its Kakao contract, didn't you funnel work to them? Min Hee-jin pushed back, saying, even if I received the contract, we were not people well versed in these agreements. We were just asking among ourselves, is this even realistic? VP Lee was an accountant, so we talked about it in that context. She continued. I didn't even properly read my own contract and ended up in this situation. Are you saying I carefully read someone else's contract and then deliberately funneled work? That doesn't make sense. Shin Woo-seok charged extremely low labor costs. With the budget for one HYBE project, we produced 5 or 6 videos. You can tell just by comparing the numbers. How could this be favoritism? We saved costs by shooting multiple projects during a single trip. This is a forced argument and a smear. So, that was a portion of this article. So during the hearing, where Min Hee-jin appeared as a witness for Shin Woo-seok, what have you learned? It came out that the Kakao shareholder agreement was shared internally and discussed and passed around. And Min Hee-jin herself, as we just saw, acknowledged that she had received the contract and reviewed it and discussed it with Lee Sang-woo, the former ADOR vice president, who has a finance background. And that means the documents was no longer confined to Kakao and Dolphin Kidnapping Crew. It entered a wider internal communication loop. And once that happens, control is effectively gone. And what makes this more serious is the setting, right? Because on that same court date, it turns out, according to Lee-jin, who was there in person, Kakao's legal team was physically present in the courtroom, observing the proceedings. And this was not a distant corporate relationship. Kakao was watching in real time as this confidential shareholder agreement was being referenced in open court, with multiple non-Kakao parties involved. And again, like I said, this type of deal between Shin Woo-seok and Kakao was not limited to them only. That structure, according to Top Daily, applied to other subsidiaries under Kakao. So no wonder why the legal team cared about this case. And they were kind of iffy about the fact that the agreement was being referenced in real time in court. Now, add one more layer. Min Hee-jin has been extremely aggressive in her own cases about insisting that she did not leak or circulate shareholder agreements. And there's a reason for that, because in deals like this, unauthorized disclosure itself can trigger termination clauses, and the agreement can be voided as a result, and penalties can be enforced, and obligations can accelerate. So when you line everything up, it's pretty interesting, right? This isn't just the witness helping Shin Woo-seok. This is someone who stepped into court, brought a highly sensitive shareholder agreement into open discussion, and potentially exposed all parties involved to serious contractual risk. Now, let's go back to today's update. Okay? Again, Dolphin Kidnapping Crew has officially appealed, and they're not accepting the first instance ruling that ordered them to pay 1 billion Korean won to ADOR. And along with the appeal, what have you learned? They also filed for a stay of enforcement, which is basically a request to pause forced payment while the appeal is ongoing. So what's likely to happen next? The appeal will move forward, but the core legal reasoning is unlikely to change unless Dolphin Kidnapping Crew can produce something fundamentally new, not a reinterpretation, okay? And not another explanation of intent. The written contract already carried, the day ones, okay? And meanwhile, attention shifts almost entirely to Min Hee-jin versus HYBE shareholder agreement case. And that is the real end game we're talking about. And compared to that, 1 billion Korean won is pretty secondary, while the amount is not, that small. And speaking of which, in that context, let me read you this article that came out on January 15th. Dolphin Kidnapping Crew loses damages lawsuit. Does this hurt Min Hee-jin? ADOR has won its lawsuit against Dolphin Kidnapping Crew, the video production company that created the group's music videos, as first-round rulings from the various legal disputes stemming from the 2024 conflict between HYBE and Min Hee-jin continue to come out. Attention is now turning squarely toward Min Hee-jin herself. On January 13th, I'm going to skip this part, so it says that the court presided over the judge issued a partial ruling in favor of ADOR in its 1.1 billion damage lawsuit. The court ordered Dolphins to pay 1 billion, blah, blah, blah. The dispute began in August 2024, blah, blah, blah. The court made it clear that what mattered was a written contract, not alleged verbal agreements, the article says. Although Min Hee-jin appeared as a witness during the hearings and testified that this kind of arrangement was standard industry practice, the court did not accept that argument. This dispute was also referenced in the NewJeans exclusive contract validity lawsuit, which was finalized last year. In that case, NewJeans argued that ADOR's conflict with Dolphin Kidnapping Crew had made further collaboration impossible and was one of the reasons they sought to terminate their contracts. But the court found that ADOR's actions were a legitimate exercise of its contractual rights, especially given that advertisers had requested the removal or re-uploading of videos from Dolphin Kidnapping Crew's YouTube channel after branding elements were stripped out. Even though the two cases were handled by different courts and dealt with different legal issues, both courts reached the same conclusion regarding ADOR's actions, reinforcing the outcome. And that's a significant part, right? The article also says, while Dolphin Kidnapping Crew may still appeal, this article came out on January 15th. The article says, while Dolphin Kidnapping Crew may still appeal, meaning this ruling is not yet final, it is clear that the momentum is moving in ADOR's favor. Following its victory in the NewJeans case, ADOR, and by extension HYBE, has now secured another favorable ruling. The real issue now is the unresolved lawsuit between HYBE and Min Hee-jin over the termination of their shareholder agreement and the return of stock purchase funds. In that case, Min Hee-jin has consistently argued that she never planned to separate from ADOR, and that documents submitted by HYBE are either casual conversations or materials she was unaware of. But similar claims were largely rejected in the NewJeans exclusive contract lawsuit, where the court found that Min Hee-jin had intended to separate from ADOR while taking NewJeans with her. While the shareholder agreement court is not legally bound by that earlier ruling, the outcome of the Dolphin Kidnapping Crew damages case makes it more likely that the court's view will not shift dramatically unless new evidence emerges. Okay, we're talking about new evidence, not new petitions by some random people. The article says, it is becoming increasingly difficult to deny that Min Hee-jin is facing an uphill battle. The final hearing in the HYBE Min Hee-jin case is scheduled for today, the 15th, with the verdict expected next month. Attention is now focused on whether the outcome will differ from the rulings that have come before. And yes, we have talked about that final hearing, and yes, the verdict will come out next month in February. Okay? So, yeah, we're nearing the end game. Now, before we wrap up, again, right before I started to record this video, Dolphin Kidnapping Crew, and by then we were talking about Shin Woo-seok, put on their own statements about this case. And I was wondering why they were being silent, because Shin Woo-seok is known for being a so-called Instagram warrior, putting out all sorts of photos and captions and stuff and statements to deliver a certain messages. Okay, so let's read the statement. This is Dolphin Kidnapping Crew. Following the first instance ruling in the damages lawsuit filed by ADOR, announced on the 13th, we have seen a number of claims circulating that differ from the actual facts. We are issuing this statement to correct the record. In its ruling, the court found, contrary to ADOR's claims, that the act of uploading the director's cut of NewJeans' ETA music video to a YouTube channel was carried out based on verbal agreements between the parties and therefore could not be considered unauthorized. The court further stated that all evidence and testimony supporting the existence of this verbal agreement were credible, leaving no reason to doubt their truthfulness. But the court also held that because the contract required written consent, the parties were obligated to pay contractual penalties for breach, even though there was a verbal agreement with ADOR CEO. By that, we're talking about, he's referring to Min Hee-jin. In addition, the court clearly ruled that no copyright infringement occurred and that director Shin Woo-seok's decision to post his own statement was appropriate. As a result, all of ADOR's damages claims on those grounds were dismissed. That said, while the court acknowledged that there was a clear agreement between the parties regarding the upload of the ETA director's cut, it nonetheless found a breach of obligation solely because the agreement was not put into writing. This conclusion is internally inconsistent. If the parties mutually agreed to substitute a verbal agreement for written consent, then penalizing one side for not formalizing that agreement contradicts the parties' original intent at the time. Okay, interesting. Accordingly, we believe the first instance court's decision runs counter not only to the expressed intentions of the parties, but also to general principles of fairness and common sense. Wow. So on January 20th, we therefore filed an appeal. Interesting. Up to now, all NewJeans music videos and related content produced by Dolphin Kidnapping Crew were created at reduced fees in order to expand our portfolio and enhance the completeness of the works. In this case as well, we submitted project-related material to the court to prove the factual background. Finally, rumors regarding the structure of our contracts are also untrue. Dolphin Kidnapping Crew operates under reasonable contracts that guarantee an independent creative environment and maintain partnerships based on mutual respect. We ask that unfounded speculation or malicious attacks be refrained from. Going forward, we intend to respond firmly based on reports and evidence to the spread of false information, organized comments, manipulation, or similar conduct. And this says, for tips, and they added the email address, monitor@dolphiners.com, encouraging their supporters to submit and report those cases of spread of false information, organized comment manipulation, or similar conduct. Wow. And they said, thank you, January 21st, 2026, Dolphin Kidnapping Crew. And then Shin Woo-seok basically shared the same thing on his own Instagram account. What do you think? I mean, the statement is carefully written. I'll give you that. And probably, I wonder, whether Kakao, they had any input into this writing, given that, their legal personnel allegedly attended the hearing. And this is pretty a sensitive matter for them as well, given the fact that it did refer to the contract in the last paragraph, right? And saying that the structure of our contracts the rumors about that are untrue. We operate under reasonable contracts that guarantee an independent creative environment and maintain partnerships based on mutual respect, meaning we're not slaves. I am not a slave under Kakao. But I don't know, the statement is kind of legally and strategically weak because first, it selectively reframes the ruling in a way that sounds favorable, but misses the core point. So yes, the court allegedly acknowledged that a verbal understanding existed, according to them. But that acknowledgement did not decide liability, because the court's holding was clear. The written contract required written consent, and that requirement controlled. And by emphasizing credibility of testimony while downplaying the contractual hierarchy, the statement kind of creates an impression of partial vindication that does not actually exist in the judgment. And also, the claim of something like inconsistency or something. Yeah, 이 모순이자. They did use the word inconsistency. That's kind of misleading because courts routinely recognize that parties may have informal understandings while still enforcing formal contractual requirements. And that is not a contradiction. It's a basic contract law because a verbal agreement does not override an explicit written clause unless the contract allows it. And the argument is unlikely to gain traction on appeal, I feel like. You might say that doesn't matter because for them, this is all about the media play. This is not meant for the court or the judges. It's meant for their supporters or the public, general public. That might be the case. And also, the statement avoids the most damaging part of the ruling, and that is provisional enforcement. Regardless of intent or industry practice, the court treated this as a clean contract breach with immediate financial consequences. And that framing is exactly what makes the appeal difficult, and the statement offers no real answer to it. And lastly, the section about rumors regarding contract structure is defensive to the point of drawing attention to the issue, right? Because at this point, I think people are not really focusing on vague rumors. They're focusing on very specific shareholder agreement terms that have already surfaced in court records and reporting. Probably thanks to, what Min Hee-jin did. We have learned that the reason why her Kakao conversations were leaked was because she was sending them as files to Lee Sang-woo, the former VP of ADOR, her associate, using HYBE's servers. And I think that is a likely route by which this contract was leaked. And it's a blanket denial. Without addressing how those terms became publicly discussed at trial, does little to reassure. We're talking about the statement again, right? And lastly, one more thing. The tone reveals the underlying problem, right? This is not written like a confident legal rebuttal. It kind of reads like an attempt to relitigate the case in public opinion, while simply buying time through appeal and enforcement suspension. And yeah, that may work as a PR move, especially for their supporters and Min Hee-jin supporters, but does not really change the legal reality established by the first ruling. So, I don't know. From my perspective, the statement kind of sounds forceful, but it does not meaningfully weaken the judgment. It simply restates arguments the court has already heard and rejected. And it avoids the hardest questions and leans pretty heavily on fairness rhetoric rather than contractual analysis. So, yeah, it does not suggest a clear path to reversal. We'll have to see. Now, before we wrap, this brings us back to September 2024, when Shin Woo-seok said just about everything imaginable to ADOR on Instagram. He went public, early and went loud and framed the conflict as a moral fight, okay? But in the end, when it mattered, he still lost in court, right? So let's, for memory's sakes, go through each of the statements, starting with Shin Woo-seok and then ADOR's response the next day and Shin Woo-seok's response on the same day. Shin Woo-seok wrote, on September 2nd, 2024, it appears that ADOR's policies have changed following the change in management, meaning after Min Hee-jin's gone. At ADOR's request for deletion, all NewJeans music videos and related content that Dolphin Kidnapping Crew had produced and uploaded up to this point, as well as videos that were scheduled to be uploaded in the future, can no longer be made public. Dolphin Kidnapping Crew channel and the Panisu YouTube channel exist primarily to archive our creative portfolio. They generate not a single one in revenue. These videos and channels were created voluntarily with the intention of making good work for fans, and they generate no financial benefit for Dolphin Kidnapping Crew whatsoever. Nevertheless, due to ADOR's changed position, all of these videos have been deleted and can no longer be publicly shared. As of today, it seems collaboration between Dolphin Kidnapping Crew and ADOR is no longer possible. Mind you, this was before the NewJeans versus ADOR case decision came out. And one of the many arguments that they raised, NewJeans and their Sejong lawyers, was ADOR did wrong because we could no longer work with dolphin kidnappers. So it's pretty obvious who the audience was for the statements and the purpose, the objective. Anyway, let me finish this first. As of today, it seems collaboration between Dolphin Kidnapping Crew and ADOR is no longer possible. There were projects we had promised to continue together with the NewJeans members, and it is regrettable that we can no longer keep those promises. I am sorry to the staff who worked through countless nights over the past few months, and above all to the fans who are waiting. Thank you. So that was what he wrote. Now, the next day, on September 3rd, 2024, ADOR wrote, "Hello, this is ADOR. We would like to clarify ADOR's position regarding the statement posted on September 2nd by director Shin Woo-seok of Dolphin Kidnapping Crew on his Instagram account. The director's cut of the ETA music video that Dolphin Kidnapping Crew uploaded to its own social media channel contains edits that were previously a point of disagreement with the advertiser, and by that we mean Apple, and it was posted without consultation with the advertiser. In addition, under the contract between ADOR and Dolphin Kidnapping Crew, the copyright to all NewJeans music videos and related works belongs to ADOR. Therefore, the ETA music video and any edited version of it, including the director's cut, must be uploaded to ADOR's official channels. This is to protect the rights of the artist. Accordingly, ADOR requested only that Dolphin Kidnapping Crew suspend the posting of the director's cut video. That only. Just that. And they said, we did not request the deletion or suspension of all NewJeans related videos, including those on the Panisu channel, nor has ADOR's channel operation policy changed. However, director Shin Woo-seok is spreading false claims, suggesting that ADOR demanded the deletion of all NewJeans related content, including the Panisu channel. We would like to clarify that director Shin's claims differ significantly from the fact, and we express deep regret regarding Dolphin Kidnapping Crew's breach of contract and dissemination of false information. We will take all necessary steps to ensure that the deleted NewJeans content can be uploaded to ADOR's official channels in the future. Thank you." Now, let's see how this guy responded in response. The very same day. And the first sentence, the first line, 뭐라는 겁니까 대체? What are you even talking about? He began his statement with, "Today, I reconfirmed by phone the agreement we reached regarding the upload of the director's cut. At the time of production, the three parties involved agreed to release the director's cut on Dolphin Kidnapping Crew's channel for the fans. Yet, ADOR's current management is now falsely claiming that Dolphin Kidnapping Crew uploaded the director's cut without authorization. Why are you dragging in unrelated third parties and engaging in media play over something that has nothing to do with them? This not only ignores long-standing norms in the advertising industry, but also betrays the basic trust required in business." It was ADOR that demanded deletions, stating that videos for which ADOR holds copyright and portrait rights can only be published on official accounts and cannot exist on third-party channels. On Sunday evening, you unilaterally threatened that unless the videos were deleted by Monday morning, you would send a formal legal notice and demand contractual penalties amounting to twice the production fee. And now you come out saying this? Did you only discover the existence of the Panisu channel after everything had already been deleted? Common sense tells you this. What director, on earth would deliberately burn their own work? What possible reason would I have to do that? The Panisu channel was an extension of the project Ditto, which I directed, and it was a channel and content I personally volunteered to create for fans without any compensation at ADOR's request. And now you're saying I suddenly deleted everything for no reason? Dolphin Kidnapping Crew worked to make the music videos good, complete works, and voluntarily took on unpaid labor for the sake of the art and the fans. And despite ADOR's unjust demands that overturned prior agreements, we deleted the videos anyway. Without even knowing what was actually agreed upon at the time, what exactly is your grievance that you feel justified in branding Dolphin Kidnapping Crew as a contract violator and spreader of falsehoods? Is it because I submitted a petition? Because I refused to produce HYBE's music videos? Or because this is part of an effort to erase NewJeans? Erase NewJeans. Whatever it is, stop distorting the truth through dirty media play. Dirty media play. And this is a kicker that he ended the statement with. You will probably do it again anyway. 이래도 또 하겠지. ADOR did not come up with any new statement in response to that, probably because they didn't feel the need to. Instead, they took legal actions. So looking back at 2024, the pattern is pretty clear. Shin Woo-seok went all in on Instagram. And speaking of which, he even uploaded like this photo, letting the world know that Apple cares about us and they are in our team. Why? Because they have sent me these iPhones and Apple, is this Apple Watch or Apple Pen? Whatever. And then he posted on his Instagram, guess what? What a coincidence. I received an award and the award arrived today. Finalist award winner, Dolphiners Films, ETA NewJeans, branded content, entertainment, craft, best use of music. And then this was a killer. He posted a photo of himself like coming out of a, what is this? It's like a, whatever, the stadium, whatever. And then with a caption, I try my best, regardless of who my opponent is when I'm in a fight, even if that opponent is an elementary school kid. So he went all in on Instagram, and he accused ADOR of bad faith, dirty media play, betrayal, and moral hypocrisy, whatever. And he framed the fight as one about creativity and fans and trust. And he was pretty loud, and it was pretty emotional and very public. In that sense, he was an Instagram fighter first and a litigant second. But when the case reached court, none of that mattered. Because again and again and again, the judges did not and do not, are not supposed to, rule on intent or vibes or industry custom. They ruled on the contract. And on that point, Shin Woo-seok lost. Like, verbal understandings, no matter how sincerely believed, did not override a written requirement for a prior written consent. And that's why today's consent statement feels pretty familiar and pretty weak, because it repeats the same logic that already failed. It leans on mutual understanding and fairness while sidestepping the clause that actually decided the case. I mean, I don't know. Public pressure and I guess Instagram narratives might win sympathy from sympathy coming out of some people, but they do not win lawsuits. And Shin already learned that once, or I hope he did. And this statement shows that he may still be fighting the wrong battle. So, I don't know. And if I remember correctly, didn't he say that he has like recordings, like voice recordings, whatever, which he brought up to threaten ADOR? But again, regardless of that, he lost. So the real question is, what happens next? Does Dolphin Kidnapping Crew actually have any realistic path to overturning this on appeal, when the core issue has already been answered in writing? And or is this appeal simply about buying time? And more importantly, how does this spill over into the shareholder agreement case between Min Hee-jin and HYBE? Does today's loss or this loss weaken Min Hee-jin's position, especially given what came out in court about a contract that was never supposed to be circulated? Curious where you land on this. Do you see a real reversal ahead, or does this already feel settled with the real fight happening somewhere else? Let me know your thoughts by writing comments, and when you do so, let's stay positive, respectful, and classy. Thank you guys. Peace and love. Bye-bye.